Hello, everyone joining. We'll get started in about a minute. Hello, everyone, and welcome to the Environmental Law Institute's event, PFAS Regulation, What's Next? A Global Perspective. My name is Madison Calhoun, and I'm the Senior Manager of Educational Programs here at the Environmental Law Institute. We have a fantastic program in store for you all, and we're so excited that you've joined us today for it. I want to take a moment to thank our wonderful speakers for taking the time to participate as well. We have a fantastic lineup of experts here today from across the globe. We're so thankful that they were able to join us. Many of them are joining from time zones that do not fall within typical business hours right now, and we appreciate their flexibility to join the webinar. Today's event will be recorded and posted to the ELI website for members to view later. So if you're an ELI member, check back to the event webpage within a few business days to find the recording. We will be taking audience questions at the end of the program, so please feel free to put your questions in Zoom's Q&A box as soon as you think of them. There's no need to wait until the end of the program. While the chat will be open for you to post observations, please put any questions that you wish for our speakers to address in the Q&A box rather than the chat. I will now go ahead and turn things over to today's moderator, Jude Arokianathar. Jude joined the Yortis Group in 2021 as a regulatory consultant following a PhD in organic chemistry and a Master's of Science in pharmaceutical chemistry. He's part of the product stewardship team at Yortis Group, where he works closely with clients from various sectors to ensure their compliance with existing and upcoming chemical and environmental legislation. Jude is a subject matter expert in PFAS, and he described himself as a PFAS enthusiast. He leads the PFAS services at Yortis Group, where he guides clients through their PFAS journey, which includes global monitoring and tracking of regulatory updates, advising on the scope and implications of these updates, and identifying PFAS contained in products, data gap analysis, engaging with suppliers and manufacturers through surveys, assessing possible alternatives, and engaging with government agencies. You can find all of our speakers' full biographies online on the ELI webpage for this event. Jude, I'll go ahead and hand things over to you. Thank you all again so much.
Thank you, Madison, for the kind introduction, and to ELI for the invitation to moderate and also speak in today's webinar. It's a pleasure to be here, and I hope, like us, you're excited for what's in store for today's discussions. PFAS regulation, what's next? A global perspective. PFAS, which stands for per and polyfluoroalkyl substances, is a very hot topic at the moment. And you can see it in from the regulatory point of view and also in the news. And it's due to its effects to human health and the environment. There's an increasing number of regulatory actions to phase out these substances. A key question, therefore, is what steps or actions are being taken or proposed globally for PFAS? So today we'll be addressing this question. And as Madison mentioned, so an impressive panel of PFAS experts will walk us through and provide their insights with key regulations in countries or regions such as the US, Europe, and Australia. So we do have across the globe, really. Next slide, please. So before we kick things off, I'm going to introduce the speakers for today. Firstly, we have to kick things off, or to start things off, we have Julia Hatcher to give us an overview of the PFAS regulatory activity in the US. Julie Hatcher is a partner in the Washington, D.C. office of Latham and Watkins, focusing on environmental, health, safety, and product defense. Ms. Hatcher possesses deep expertise in federal laws administered by U.S. EPA that control chemicals at every life cycle stage, including the Toxic Substances Control Act, TSCA, the Federal Insecticide, Fungicide, and Rodenticide Act, the Resource Conservation and Recovery Act, the Superfund laws, so CER, CLA, and EPCRA, the Safe Drinking Water Act, the Clean Water Act, and the Clean Air Act, as well as laws administered by other agencies pertaining to worker safety and chemicals in products, including in cosmetics, personal care, and consumer products. She also deals regularly with the intersection of these laws with litigation liability and with related state laws. Her expertise also extends to consumer products related requirements for labeling, reporting, green and health claims and recalls administered by the Consumer Product Safety Commission, the Federal Trade Commission, and state counterpart agencies, as well as to chemical control regimes outside of the US. Ms. Hatcher has worked on PFAS matters for over 20 years and has extensive knowledge regarding PFAS manufacturing, technologies, chemistry, functionality, supply chains, and many other facets. So we welcome Julie Hatcher, and it's a pleasure to have her. Next, we're staying with the US. Following Julie's discussions, we'll be moving on to Keegan Brown, who is a partner in the environmental law and litigation sector at Lowenstein Sandler. Keegan Brown's practice focuses on environmental litigation, environmental regulation, product liability, toxic torts, ESG, and transactional due diligence. He represents clients throughout the full life cycle of complex environmental and products liability litigations and regulatory matters. He has successfully defended claims in numerous federal and state courts across the country, including the first two natural resource damage actions to ever go to trial in New Jersey, both of which resulted in complete defense verdicts. He also regularly counsels buyers, sellers, lenders, and underwriters on the full spectrum of environmental issues that may affect transactions. Keegan has extensive experience addressing litigation and regulatory matters involving natural resource damages, contaminated sediments, and emerging chemicals of concern, particularly PFAS. He has been recognized by both Chambers USA and Legal 500 for his expertise in environmental and toxic tort litigation, including PFAS litigation. So we welcome Keegan Brown, and again, pleasure for him to be here to talk about the US. And then moving across the globe, we'll next be going with the EU and the regulatory actions regarding that. And Martin A. Alhaus will be presenting that. And he's a founding partner of Product Kanzlei, a boutique law firm specializing on EU product legislation with offices in Augsburg and Berlin, Germany. Mr. Alhaus specializes in issues of chemicals legislation, including REACH, CLP, BPR, POPs, and product-related environmental law. He advises companies from multiple industries on product compliance and product stewardship projects, including projects on PFAS. He also represents companies in relevant regulatory and judicial proceedings at national and European level, e.g. for example, before the Board of Appeal of the European Chemicals Agency and European courts. He represents a variety of consortia and is a member of industry expert groups assisting clients in advocacy projects vis-a-vis the European Commission, the European Chemicals Agency, or EU member states. I would be interested to hear from the EU side, and we welcome Martin to present on the EU side. Now we'll be moving on to the other side of the globe. So we do have a lot of coverage globally. So from Australia, from Anna White. And Anna is a partner in the Environment and Planning Practice Group at Cause Chambers Westcard Lawyers in Australia. Cause is Australia's leading independent law firm with offices across Australia and in Papua New Guinea. Anna is a specialist in environmental regulatory compliance, contamination response, environmental prosecutions, environmental impact assessment, and approval requirements. She practices across both Victoria and Queensland, advising government and private sector clients on major transport, energy, and other iconic infrastructure projects, where she has encountered PFAS in both an advisory and conscientious capacity. Anna was the lead environmental lawyer advising the construction contractor on a dispute involving the unanticipated discovery of 3 million tons of PFAS contamination on a road tunneling project in 2019, which resulted in one of the largest construction contract settlements in Australia in recent years. Just a heads up also, before we move to the Q&A session, when we open it up, I'll also give some insights from my point of view as a chemical and environmental regulatory consultant at Yodas Group. So without any further ado, I'll give the floor to Ms. Hatcher, and it's a pleasure to have her. The floor is all yours. Thank you.
Thank you, Jude, and thank you to ELI for inviting us to be part of this program. I'm very pleased to speak with you today about U.S. regulatory activity surrounding PFAS. So let's get into it. Next slide. So I wanted to begin with this slide really as a reminder of the breadth of PFAS applications in the value chain. As this slide exhibits, PFAS applications span a wide range of industries, including a number of industries that serve critical missions, such as medical devices and medical products. And as a result, it's important, in my view, to bear in mind that any regulation of PFAS has the potential for far-reaching economic and societal impacts. Next slide. So in the world of PFAS, I think most of you are familiar with long-chain PFAS, which means fluorinated chemicals with a longer carbon chain, generally a chain of 8 or more carbons. And this slide shows the structure of 2 long-chain PFAS that are well known and that are generally no longer in commerce around the world today. PFOS, which was used historically in a wide range of waterproof and grease-proof coating applications, and PFOA, which was used to produce nonstick coatings as well as to manufacture fluoropolymers. Next slide. So when it comes to regulating PFAS beyond PFOS, PFOA, and other long-chain PFAS, a threshold regulatory question is how to define PFAS. And this visual shows a range of definitions from the broadest to the narrower definition. And what I wanted to highlight here is this second row of the visual in particular, which covers the PFAS definition adopted in 2021 by the OECD, which is an international organization under the United Nations umbrella. And this OECD definition covers literally thousands of commercial substances, and you'll hear more about this later from Jude in his remarks. But this OECD definition essentially defines as PFAS any substance with at least one fully fluorinated carbon atom, meaning any substance with at least one carbon atom that is bonded or attached only to fluorine atoms. And questions have been raised regarding this definition and whether it's too broad to use in regulations, because not all PFAS or substances falling within this definition pose the same risk, and in some may pose, no or minimal risk. Next slide, please. So let's talk about the state of play in the regulatory front definition-wise. So on the question of whether the OECD definition is appropriate for regulation. In the U.S., at the federal level, the primary EPA office in charge of chemicals has consistently declined to rely on the broad OECD definition in its proposed and final regulations, and instead has opted for a structural definition that still covers hundreds of substances, but doesn't include the so-called either super short substances with only one fully fluorinated carbon atom or lightly fluorinated substances that are included in the OECD definition. It's not clear what definition other EPA offices might use or other federal agencies in the US. That's just not clear yet. On the other hand, at the state level in the US, there are a number of states that have enacted laws recently that use the OECD definition, but they generally express it, in a little bit more simple terms as shown on the slide. And as you'll hear about from Martin, in the EU, at least their restriction proposal also uses the OECD definition. Next slide. So let's talk briefly about why the EPA Chemicals Office has declined to rely on the broad OECD definition. In a recent regulation promulgated last month, this office explained that EPA's focus is on PFAS that are both likely to be in commerce and likely to persist in the environment. And as this quote indicates, EPA believes that the super short PFAS and lightly fluorinated PFAS that are covered under the OECD definition are unlikely to persist in the environment or degrade to substances with toxicological or physiochemical properties that are similar to the long chain PFAS, such as PFOS or PFOA, or more medium chain PFAS like Gen X. Next slide. So I want to touch briefly on some of the regulations that EPA's Chemicals Office has recently finalized pertaining to PFAS. And in the interest of time, we won't be able to cover them in depth, but just want to highlight quickly. So as shown in the far left box, in June 2023, EPA listed additional specific PFAS on the EPRA Toxic Release Inventory, or TRI, and EPA's action to list PFAS on the TRI was actually mandated by the National Defense Authorization Act passed by Congress in 2021. And pursuant to the Act's mandate, EPA has been undertaking hazard evaluations of specific PFAS and then, proposing and then finalizing them for listing on the TRI. And this is going to be continuing. They're going to continue this process, to add specific PFAS to the TRI. And in a related action, which is the third box from the left, EPA in October of 2023 finalized a rule that eliminates the de minimis exemption from TRI reporting for PFAS. And this rule will apply to the 2024 reporting year, and those reports are due in July of 2025. So what that basically means is that by the end of 2025, TRI reporting for PFAS should begin to provide potentially significant additional information about PFAS emissions to environmental media from facilities around the US, and much of that information will be public. And then also in October of 2023, EPA took a significant step in promulgating a PFAS reporting rule that also was mandated by the National Defense Authorization Act. And this rule, I think, is worthy of some special focus. Next slide, please. So the PFAS reporting rule requires a one-time report that is due for most companies on May 8th, 2025. And the report is supposed to cover all PFAS manufacture and import, with PFAS defined using the EPA Chemicals Office definition, dating back to January 1, 2011. So dating back quite some time. And the rule basically applies to companies that engage in 4 types of activities: manufacturers and importers of PFAS as a separate chemical substance, manufacturers and importers of a mixture that contains 1 or more PFAS as a component, manufacturers that produce PFAS coincidentally during manufacture, processing, and use of another chemical substance, including production as part of research and development, and then finally importers of an article containing 1 or more PFAS. So I think maybe to state the obvious here, it can be very challenging, particularly for a company that imports a mixture or an article, to determine whether it contains PFAS. That information may not be in standard information sources for a mixture, such as a safety data sheet, and likely would not be included in documentation surrounding an article. And so with respect to this very challenging situation, EPA and the PFAS reporting rule relies on the same standard that applies under a different TSCA reporting rule known as the CDR, or Chemical Data Reporting. And basically, the obligation to report must be based on due diligence regarding what is known or reasonably ascertainable. And in the regulations, that's basically defined as all information in a person's possession or control, plus all information that a reasonable person similarly situated might be expected to possess, control, or know. And there's so much more to say about the PFAS reporting rule, but in the interest of time, let's conclude with a review of some other initiatives on the horizon. Next slide. So this slide identifies EPA regulations that have already been proposed and are expected to be finalized either later this year or in 2025. And I think it's fair to say that all of these regulations, if finalized, will have far-reaching impacts. First, as Keegan will highlight shortly, when finalized, the Circular Hazardous Substances listing for PFOA and PFOS, as well as shown on the far right, the RCRA actions, will basically trigger Superfund investigation and remediation for PFAS, as well as coverage of PFAS under the RCRA corrective action program for permitting and related investigation and remediation. And these regulations will certainly be a catalyst for various forms of PFAS contamination related litigation. Similarly, the Safe Drinking Water Act proposal, if finalized, will impact drinking water systems nationwide. It will require testing for specific PFAS by all systems and actions by any system where a specific PFAS covered by the rule exceeds the maximum contaminant level, or MCL, for that PFAS. And such actions by water systems, of course, in turn, may spur follow-on litigation for PFAS contamination of the system, as well as for exposure of the population on that system. Next slide. Finally, I won't have time in these opening remarks to cover these other notable PFAS initiatives shown on this slide, but I did want to emphasize that EPA has made PFAS-related enforcement a priority, and that in addition, beginning next year in 2025, the state PFAS laws that I mentioned largely kick in terms of reporting, as well as product bans of certain types of products under those laws. So with that, thank you, and I will turn it over to Keegan.
Great, thank you. Thank you very much, Julie. So I wanted to provide sort of a current update on where the U.S. litigation is headed with respect to PFAS. If we go to the next slide, please. So just to level set, PFAS litigation has certainly been going on for many years and has been going on in a significant way for at least the last, 5 to 10 years. That trend continues. There is the multi-district litigation related to the aqueous film forming foam that is in federal court in South Carolina. Those lawsuits typically name as defendants alleged PFAS manufacturers and companies that are alleged to have made fluorosurfactants that went into the AFFF. We then have different claims against PFAS manufacturers that are not related to firefighting foam. So those can be companies that either make some of the individual PFAS compounds or they make fluoropolymers. And then there are sort of a series of consumer-facing lawsuits, which are becoming a larger slice of the overall litigation portfolio in recent years. In the AFFF multi-district litigation, I just wanted to flag for everyone, the court has identified 2 bellwether cases for the Telemer defendants group. So these are companies that are alleged to have made fluorosurfactants that went into the AFFF. Those 2 bellwether cases are now proceeding into case-specific discovery that is set to conclude this summer, and the first trial of one of those cases is set for September 23rd of 2024. So we will continue to see substantive rulings relating to PFAS that may have significance far beyond the AFFF MDL coming out of that proceeding in the coming months. In the PFAS manufacturer space, one of the recent developments relates to the Hardwick litigation. This was a putative class action that was filed by a firefighter who had 5 specific PFAS compounds in his bloodstream. He sued 10 different companies who he alleged manufactured 1 or more of the PFAS that wound up in his blood. At the class certification stage, the district court certified a class of all residents in Ohio, which was actually a reduction from the plaintiff's proposed class, which would have been everybody in the United States, essentially. On appeal of that class certification decision, this past November, the appellate court reversed and decided that the plaintiff did not have standing to bring this claim, principally because the plaintiff did not establish the element of traceability under U.S. standing law. Essentially, the court said that because Mr. Hardwick was unable to allege plausible facts that each defendant were likely a cause of 1 or more of the PFAS in his blood, he could not bring claims against the defendants. It's a pretty significant ruling because it reinforces the need to really have factual allegations that tie a specific alleged injury, here PFAS in the bloodstream, to a specific defendant's alleged misconduct. And because that was lacking, the appellate court dismissed the case. So that certainly is an important development. Mr. Hardwick was seeking to have a medical science panel appointed by the court that would then further investigate the risk of certain diseases being caused by exposure to PFAS. So the Hardwick case will probably have implications moving forward in the US. And then this last bucket of consumer-facing litigation, these claims are becoming more and more prevalent. They generally rely on allegations that the defendants either said they had a sustainable product, said that they were, focusing on environmental stewardship, but allegedly were not doing so because there is PFAS in 1 or more products that they did not disclose to the plaintiff. So these typically are putative class actions that are seeking economic damages. And in addition to sort of the food and beverage category where you've got, allegations that the food packaging doesn't disclose to the user that it's got PFAS and cosmetics. You're also seeing similar claims. You've got dental floss claims, mattresses for children, fluorinated containers, women's underwear. Sort of the universe of consumer-facing PFAS claims continues to increase. And while these claims are, at least facially, economic putative class actions in the sense that the argument is, look, I paid $10 for this product because I thought it was sustainable. If I knew it had PFAS, I would have only paid $5. And so there's a delta there. It seems, based on the way these complaints are being filed, that a future series of claims relating to personal injury or medical monitoring is not far off. Also been some notable settlements in the last couple of months. In the AFFF MDL, there were two major settlements, one involving 3M and one involving DuPont, Chemours, and Corteva relating to public water supply claims. You can see the amounts there on the slide. These are very substantial dollar amounts, and the settlement agreements are very comprehensive. While there are releases of liability provided in these settlements, those releases do not cover personal injury claims. They only cover drinking water claims. And so to the extent there are damages that do not arise from or relate to the alleged harm to drinking water, those claims are still preserved. The district court in South Carolina approved the 3M settlement on February 2 of this year, and the final, the fairness hearing for the 3M settlement was on February 2 of this year. The DuPont settlement was approved by the court on February 8th of this year. So it will be in the coming months when we will get a final decision on the 3M settlement. And then lastly, I mentioned the Solvay Specialty Polymer settlement of approximately $394 million. This is an extensive settlement that involves commitments by Solvay to perform additional investigation and remediation work around a manufacturing facility in New Jersey, and also pay $75 million for natural resource damages in exchange for broad releases from the state of New Jersey. If we go to the next slide. So as Julie mentioned, there's all this PFAS regulatory activity that is happening in parallel with the litigation landscape. And I think as we continue to see more regulatory action, it's anticipated that there will be an uptick in litigation claims. Certainly with respect to the CERCLA statute or the Superfund statute here in the US, once PFOS and PFOA is designated as a hazardous substance under this statute, we're going to see a very substantial number of cost recovery and contribution claims that are filed under that statute to try to recover investigation and remediation costs at contaminated sites. You will also see an increase in natural resource damage claims. As I mentioned on the prior slide, with respect to the Solvay settlement, there are certainly some natural resource damage claims that are being pursued currently, but not under the federal Superfund statute. Once PFOA and PFOS are listed CERCLA hazardous substances, we're likely to see more natural resource damage claims under CERCLA. And then the reopening of closed sites. For any contaminated site where there is some amount of contamination being left on site, the statute requires that the U.S. Environmental Protection Agency, or whoever the lead agency is for that site, conduct a periodic review of the conditions of that site at least every 5 years. It is likely that as part of the 5-year review process, some sites that have previously been closed are going to be reopened administratively, which is going to result in additional investigatory and remedial work. That will then result in a fresh look at who might be responsible for paying some of those increased costs, particularly if those costs relate to PFOA or PFOS. We also have reporting violations. As Julie mentioned, there's the Toxic Substances Control Act reporting rule, which is going to mandate reporting for many companies going into May of 2025 to get the reporting in. Once that information is reported, it's anticipated that there will be either the information will be directly accessible, or interested individuals and plaintiffs' lawyers will submit Freedom of Information Act requests to obtain information on who's been reporting which PFAS and for what quantities. And the same thing with some of these state reporting statutes that Julie mentioned. As more data becomes available, it is inevitably going to be part of the universe of information that is considered when people are evaluating which litigation targets to focus on and what claims to assert. And then finally, the increase in sustainability claims. Again, we've been seeing that for some consumer-facing sectors, as I think Julie's slide earlier very aptly points out, because PFAS is in the value chain in so many different locations. This idea that you would bring a claim on the theory that I thought the product was sustainable because you didn't mention to me that it had PFAS, that type of theory could be easily replicated into a broader universe of consumer-facing claims. And while they may start as economic damage claims, ultimately those claims create an opportunity to have a more robust conversation about, is there causation for personal injuries? Do we need to, pay somebody for personal injury damages, or is the causation science not yet there? And in fact, we need to go the medical monitoring route, which can help circumvent some of the scientific shortcomings. So I think all of these things are, to come in the next couple of years with respect to PFAS. And thank you again to ELI for inviting me to speak here today. And with that, I will pass it over to Martin.
Thank you, Keegan. And thank you to ELI for having me for this webinar. So although litigation is also emerging in the EU, I would like to highlight some regulatory developments on the EU law. So next slide, please. So the regulatory status is as follows. As Julie already mentioned, the EU is strongly focusing on the OECD definition of PFAS, although there is, of course, already a set of regulations in place addressing specific prohibition of certain PFASs. For example, those PFASs which are already regulated under the Stockholm Convention and correspondingly in the respective EU regulation on POPs, on persistent organic pollutants. Nonetheless, the European Green Deal already addressed the PFAS as an issue of concern, claiming those being forever chemicals, which is a rather famous expression used by the Commission and the European Chemicals Agency, as well as other member state competent authorities, to address the issue and make that public to come to public awareness. Under that chemical strategy for sustainability, additional restrictions and prohibitions are addressed, one of which is a ban for the use of all PFAS as a group in firefighting foams, so in a specific use. That process is already underway. It's in its final stages. There was a final conclusion on that by the corresponding committees at level of the European Chemicals Agency. In parallel to that proceeding, which is of more interest, of course, 5 member states of the EU have submitted an even broader restriction proposal to cover a wide range of PFAS uses. That proposal was prepared for a couple of years and was finally submitted early in January of last year. It is abbreviated as the UPFAS restriction, or the Universal PFAS restriction. Next slide, please. That restriction, as other restrictions as well, is based on Article 68 of the REACH regulation, so the basic chemical legislation of the EU. REACH in that sense stands for the registration, evaluation, authorization of chemicals. What is missing is the R for restriction in that abbreviation, but that is exactly what we are talking about. So the restriction proposal that can be used as a regulatory measure in case there are risks associated with a specific substance and its uses to humans or the environment, and these risks cannot be adequately controlled, so it requires a corresponding restriction on EU level. And any of these decisions to implement a restriction has to take into account socioeconomic impacts as well as the availability of alternatives. So it's a multi-stage approach that needs to be covered, and we're in the middle of that process with respect to the PFAS restriction. Next slide, please. The restriction proposal, which is under assessment, and I'll come to that in a second, is also based, as any other restriction proposal, on that article. So the main focus is a rather generic prohibition of all PFAS uses. So the restriction proposal is based on the OECD definition with some minor changes. So some subgroups are excluded from that definition because it is considered that these subgroups do not qualify as being persistent, which is the main driver for that universal PFAS restriction proposal. Having said that, the users which are subject to the restriction proposal are basically any and all users. So placing on the market of PFAS as such, as a constituent of other substances in a mixture or in an article shall be prohibited, at least if certain threshold limits are exceeded. However, there's a broad variety of exemptions and derogations proposed in that proposal, some of which are still under review and require further assessment, some of which are basically considered as already finally assessed. So there is sufficient evidence that no alternatives are available or the socioeconomic impacts are as high as estimated, and therefore a restriction is not appropriate for that specific use. Irrespective of these specific derogations or exemptions, in general, the restriction shall apply within 18 months after the entry into force. So that would be the starting date for that prohibition, and derogations will be granted for additional 5 or 12 years. So in total, it will be 6.5 or 13.5 years prior to the entry into force of that prohibition. Next slide, please. The restriction process started with the proposal. That proposal has been published on the ECHA webpage and was subject to a public consultation process, which lasted from March last year to basically end of September last year. And at the moment, the corresponding dossier submitters, as well as the Socioeconomic Analysis Committee and the Risk Assessment Committee at ECHA level, are assessing the proposal as well as the submissions from the public consultation. That process is ongoing. ECHA has already addressed that they will approach the entire assessment process on a sector-by-sector basis. So they will look at the specific users belonging to a specific sector one by one to see whether there are any specific requirements, socioeconomic impacts for a corresponding sector or corresponding use that need to be considered. That process is ongoing. There will be a first meeting of the Risk Assessment Committee in February, which will hopefully see a decision on a time schedule, on a plan, how to proceed with that sector-by-sector assessment and approach. According to statements from competent authorities, it's not very likely that the entire assessment will be completed already this year. It's rather likely that we will see final opinions early in 2025. So the opinion development phase will presumably not come to an end prior to early in 2025. And subsequently, the Commission is in charge to adopt the corresponding decision on the restriction. And only after that, the corresponding derogations or the prohibition after the 18-month period will enter into force. So that is basically the actual status. Next slide, please. With respect to that approach, which is rather unique under the REACH approach due to the broad variety of substances which will be covered by that restriction, we have not seen anything like that under REACH before. There are a lot of legal concerns which have been addressed in the public consultation on the political landscape on national level as well as on EU level. One of which is that some details with respect to the precautionary principle are not met. That means due to the lack of scientific evidence. The precautionary principle under EU law requires that there is a scientific basis, but the scientific basis is not sufficient to come to a binding conclusion. And only at that stage, the precautionary principle comes into play. Now, the concerns are that the grouping approach on basis of the assumption that all PFAS qualify as persistence and therefore require a corresponding restriction and prohibition is not supported by scientific evidence. Another aspect is that the potential risks from a broad variety of PFAS is still unknown. So there's no sufficient scientific evidence for the entire group of PFAS that will be covered by that restriction proposal. So from that perspective, a broad variety of legal concerns are addressed in the public consultation, and it seems that regulators are willing to at least further assess those comments and those concerns, not saying that they will follow those concerns and amend the corresponding proposal, but at least there is a further discussion on the need of further scientific evidence and further efforts on that end. One specific issue for that proposal is, of course, and that refers to the last indent on that slide, that the proposal seems to rather estimate that a corresponding exposure and related risks can be derived just by looking at those PFAS which are reasonably assessed due to prior regulations, like for PFOS or PFOA. But it is quite unclear, and even the proposal is quite unclear on that one, how the knowledge and the scientific evidence from those specific PFAS can be transferred to the broader group without having any additional data available. Next slide, please. Another concern that is addressed in the public consultation is a violation of the principle of proportionality. So with respect to the derogations that are proposed in the restriction proposal, which is either a 5 or a 12-year derogation, there is no possibility provided, at least it's not proposed in that proposal, to extend that time period. To make that point clear, the 5-year period will be granted for those users for which alternatives are basically available, but it requires additional effort to make them available on an industry scale, so for the entire market. The 12-year exemption or derogation will be granted in case there is a likelihood of available alternatives, but they need to be developed. So there's further R&D process that is necessary to come to a corresponding alternative. But the entire proposal does not address the issue, what happens if none of these assumptions hold true in the end? So in case no alternative will be available or R&D processes fail to develop corresponding alternatives, the proposal does not foresee any additional review period or further amendment process. So that will be subject to a separate approach and cannot be initiated proactively by industry, which is definitely a downside from an industry perspective. Another aspect that is addressed is that the entire approach seems to follow a principle which belongs to another regulatory approach on the REACH, which is the authorization process. Under the restriction process, so the process under which the restriction proposal now is prepared, in general, the approach is all users are allowed except those which are subject to the restriction. Under the authorization approach, the concept is different. All users are prohibited unless an individual company has been granted a corresponding authorization for a specific use. The proposal seems to use that authorization approach and states, well, we want to prohibit any use relating to PFAS, irrespective whether it's the PFAS manufacturing process, whether it's a use of a PFAS containing mixture or a PFAS included in an article, unless we receive sufficient and convincing information that an exemption or derogation is necessary, which is similar to the approach in an authorization process. However, there is no specific procedure for such an approach under the restriction regime. So the position of industry is rather weak, although the same principles according to the authorization approach are somewhat applied. So that is also considered a major downside for industry. And there seems to be a broader contradiction with respect to the justifications as provided in the restriction proposal. So on the one hand, there is a clear statement that predictive tools are not available when it comes to the environmental assessments or availability of PFAS in, for example, water compartments, in soil or other compartments. However, the proposal at the same time outlines specific predictions for concentration of PFAS in the environment. So knowing that predictive tools are not fully available, a corresponding prediction is provided in the proposal. Another concern is that all PFAS are, in essence, considered hazardous, although the proposal clearly submits that a hazard assessment is only available for certain substances and not for all substances covered by the restriction proposal. And a variety of conclusions is drawn in knowledge of a lack of scientific evidence and in knowledge of existing uncertainties. So there's a clear lack of corresponding data and knowledge addressed in the proposal. Nonetheless, on that basis, the restriction is nevertheless proposed. So it will be interesting to see how the authorities will deal with all those concerns, save of all the other concerns which have been submitted with respect to specific users and specific sectors, from medical industries to kitchenware to other things. So that is subject to further assessment, and the outcome of that assessment will presumably be available not any earlier than early in 2025. Next slide, please. So with that, I will hand over to Anna to see what Australia is doing with respect to PFAS. Thank you.
Thanks, Martin, and thanks to the ELI for the opportunity to be here with you all today to talk about such an interesting topic, which is evolving, of course, across the world in different ways, with many jurisdictions, including Australia, looking to the experience overseas and drawing on some of that experience. Today, I was going to talk to you about the chemical regulation approach in Australia to PFAS, as well as the intersection between the chemical regulation and the contamination and waste management regulation regimes in Australia, and in particular in that context, to have a look at the reality for the problem, I suppose, that PFAS is presenting in a construction context, particularly by reference to a case study that has gathered some international attention because of the scale of the dispute that was generated by the unanticipated discovery of large volumes of PFAS-impacted waste. So just on the next slide, if we could, in terms of the chemical regulation regime in Australia in relation to PFAS, whilst Australia has ratified the Stockholm Convention, there's been a regulatory lag, if you like, in Australia in terms of how the amendments which have listed, the three usual suspects of PFOS, PFOA and PFHXS has been adopted domestically. We have got a chemical regulation regime implemented at our Commonwealth level in terms of our the heads of powers to regulate these matters between the Commonwealth and the state. So the Commonwealth is responsible for dealing with PFAS chemical regulation in Australia, but it has taken some time for work to be done to look at how various PFAS chemicals will indeed be managed domestically. There is now an intention after a fairly extensive consultation period that the manufacture, import, use, that is use in its own right or use as a mixture, and the export of the PFOS, PFOA, PFHXS will be banned from 2025 onwards. The grouping there for this ban is not as broad as the OECD definition. It is certainly the specific compounds to which the ban will apply. So this has been long awaited, but it is coming through now, and that will be a significant development in Australia. For some time, particularly at the state and territory level, in the absence of any ban for managing PFAS compounds, some states and territories have, if you like, not wanting to wait around, have moved ahead themselves to implement bans to the extent that they have been able to do so through a phased out process in state legislation, which has been targeted specifically at AFFF containing PFAS and the phase out of, in particular, the long chain compounds, which has progressed across a couple of jurisdictions, not all, but has been a gesture of trying to get a harmonised approach bit by bit developed in Australia. But certainly the development of the ICAMS listing will be a significant development in Australia in a couple of years, well, next year at this point. When we think about chemical regulation, then of course, there's a reality that until we've managed the production of the chemicals and the use of the chemicals, we still obviously have a high degree of awareness now about the extent to which PFAS is found already within our consumer products and in our environment in terms of managing contamination and waste issues. And it's in this space really that in Australia there has been much activity in recent years where we have had efforts to implement a unified, a harmonised approach across our various jurisdictions, because environmental matters and waste matters are regulated at the state level, to develop a common set of rules in terms of regulating safe drinking water standards and acceptable levels of PFAS in soil, water, surface and groundwater, and setting the ecological criteria for the purposes of determining what the appropriate management requirements are for certain contaminated sites. We do have an intergovernmental agreement in place, which has set a framework for the work that is to be done to look at what needs to be set in terms of regulatory positions on setting that PFAS guidance. But for the moment, that work has really culminated in what remains only a guidance document, which is called our PFAS National Environmental Management Plan, or our NEMP. The NEMP is a very important document in Australia because it, for the moment, really is the central guide to how PFAS issues are going to be managed on the ground. But it is subject to application by the relevant state and territory-based environmental regulators. And it is in that space that we do have still some inconsistency in how certain decisions around appropriate levels of PFAS can be managed in certain contexts. In terms of the litigation in Australia that we are seeing unfolding at present, for context, Australia has not had the major PFAS manufacturers have not had a presence of manufacturing in Australia. That has meant that to date there haven't been claims, well, that is one of the factors which has contributed to the fact that to date there haven't been claims made directly against the PFAS manufacturers. That is not to say that that won't change into the future. Australia has very strong consumer protection laws under which claims for misleading and deceptive conduct in relation to consumers buying products not aware of the PBT characteristics of PFAS have potential claims against the manufacturers themselves, particularly in relation to the foam products. So the manufacturer space is certainly a litigation area that is on the horizon in Australia. More immediately, however, we do have had a number of class actions have already been initiated and some settled in relation to PFAS claims surrounding Department of Defence, Army bases and airport sites. Similarly, we have had and continue to have a number of claims in relation to our airport sites across the country, together with petrochemical sites, particularly in the bulk storage facilities, often in those port areas, which will be similar to, of course, the issues that are encountered in other jurisdictions across the world. If we could just move to the next slide. I wanted to particularly mention a particular case study that I have been involved in Australia because it highlights a helpful example of the evolution, at least in the Australian domestic context, of the reality of discovering PFAS on a project and how that can influence the development of policy and regulatory change in a particular jurisdiction. And as I mentioned before, this particular case study did achieve not that it wanted to, but did achieve some recognition internationally because of the scale of the dispute that unfolded from the discovery of PFAS on this matter. So I'll just spend some time now talking through this example for those reasons. So this is the Westgate Tunnel project. This is a big build project for the Victorian government. It's originally it was quoted as being a $3.5 billion project, which was designed to deliver a major new tunnel access road into Melbourne. For those of you who haven't had the opportunity just yet to get to Melbourne, it's a city of about 6 million people, and there's a high degree of congestion on the west of the city, which meant that there was a need for a new freeway access point to be established to alleviate some traffic congestion. And the only location really feasible for this project to be delivered required 2 twin tunnels to be built, about 2.5 miles each, below the west of Melbourne. And at either end of the tunnels, there would be freeway expansion and extension components at surface level. And the image you can see on the screen there is one of the architecturally designed ventilation features that is designed to sit over one of the portals at the entrance to the tunnels. And in the background, you can see the city, and this is located right near the Port of Melbourne, which of course is a site where, like any port with the bulk storage facilities and historic land uses there, presents a particular risk of PFAS. And in this case, the Port of Melbourne had in fact, a site within the port had been subject to a major fire event in the 1980s that attracted great attention. So this project, this $3.5 billion project, attracted great attention if you just click on the slide, because in the last few years, this project was meant to be delivered without encountering any problems of the nature that were encountered, but ultimately PFAS was discovered on this project, which I'll talk through in a moment. That meant that this turned into a major delay on one of the Victorian big build projects, caused a huge amount of anxiety for the community, and also resulted in a major cost blowout for the state, which is always a highly undesirable thing. So just if we turn to the next slide, I just wanted to talk through how this evolved, because it is quite interesting and reflects a perfect storm of events that can certainly happen in many jurisdictions. The original project timeframe for this project involved an environmental impact statement in the usual way for major transport projects, involving linear infrastructure and indeed tunnels. The EIS was completed in late 2017. And as part of that EIS process, baseline contamination investigations were undertaken to look at potential contaminants of concern across the alignment of the project. And PFAS was, this is at a time when perhaps PFAS was not as widely understood, certainly in the Australian context, as it is now. PFAS had been identified to some extent, or had been considered to some extent, in the soil investigations, but not at all considered, so not sampled, in the groundwater investigations. And the baseline assessment reports indicated that should PFAS be encountered during the course of works, that would be appropriate for the contractor to go off and have a conversation with the EPA to determine what to do in that situation. So shortly after the EIS is complete, the contractual arrangements are put in place for the state to deliver this project. And this project is being delivered through a public-private partnership, a PPP, which in some jurisdictions is similar to a privately financed infrastructure project. The PPP contractual arrangements involved a project company being appointed in the first instance, who would have the obligation to design, construct, and then operate the highway over a concession period of about 20 years. And they didn't actually want to have to design or construct it, so they appointed downstream a design and construction contractor, and it is the design and construction contractor that I was acting for in this particular matter. So shortly after the contracts are signed, the EIS is being completed, construction commences on this project, almost straight away. And the plan had been originally that the project would take through until 2022 to be completed. We, of course, did have COVID in the mix there, so that is relevant in the background to all of this. But the main issue that caused the delay on this project was PFAS. And if we could just move through to the next slide. And if you just click again, and it'll all come up. Thank you. So about 6 months after construction commenced on this project, in the usual way on any construction project of this nature, ongoing works are undertaken to further investigate contamination across the site to build out that baseline data that had been prepared during the EIS process, and also to further refine the conceptual site model in relation to the subsurface conditions that are expected to be encountered by the 2 tunnel boring machines that are digging the 2 twin tunnels. And by June 2019, sufficient statistical data is available to support a conclusion that in fact PFAS is likely to be encountered in both tunnels, in soil and groundwater. And so at that time, no rule book is in place in terms of the EPA's expectations around PFAS management. So as set out in the EIS, the contractor goes off and has a chat to the EPA to say, what would you like us to do about the PFAS? Knowing that at this point, this could be quite a significant issue, given the volume of soil coming out of the tunnels is 3 million tonnes. And to put that into perspective, that is enough spoil to fill, for those of you who are familiar with Melbourne and our Melbourne Cricket Ground, which is a major stadium. If you don't have an image of it, I understand Taylor Swift was there just last week. She is in this massive stadium, which would not be big enough to hold the 3 million tonnes of spoil coming out of this project. So knowing now that we have PFAS potentially impacted across this volume of material, a question is asked to the EPA: how do you classify this waste spoil, which is not a dry material? It's a very wet, has a high moisture content, owing to the amount of water that's required in the tunnel boring machine process. And the EPA says, yes, whilst the levels of PFAS are very low and in many instances below the then safe drinking water standard in Australia, the detections are above 0. In fact, some of the detections are at the ultratrace levels of 0.00023 micrograms per litre, which is our high conservation value species protection level. And the EPA determined on that basis that all of the spoil in the tunnels needed to be treated as a regulated waste. This presented a problem for the project because once you have a regulated waste, it can only be disposed of at a licensed receiving site. And the suitable licensed receiving sites in the vicinity of the project were licensed landfills. And the EPA had advised that it was not possible to use those landfills because if the 3 million tonnes of soil coming from this project were to go to licensed landfill, that would displace all of the available capacity in those landfills that's set aside for municipal purposes. So therein unfolded a dispute where the decision was made not to turn the tunnel boring machines on, which was a highly contentious decision at the time. But knowing that there was no receiving site set up to receive the spoil, which would be about 400 truckloads a day, the decision was made that it would be unwise to turn the TBMs on until a particular receiving site had been identified and approved by the EPA. There unfolded then a reality that the rulebook didn't really deal with establishing PFAS-specific containment facilities, receiving sites. And so we then had to see the state move to introduce legislation through the Environmental Protection Management of Tunnel Boring Machines spoil regulations were introduced to establish a new framework in order for the spoil to go to a particular receiving site according to an authorised new permission framework. In parallel with that, then a number of sites were explored. There was a dispute that unfolded in parallel in relation to the jurisdiction points as to whether or not this dispute should proceed to arbitration or not. Whilst that was happening, work is happening on the ground to identify potential receiving sites. Ultimately, 3 receiving sites are identified. These are sites that have to be really established from scratch in terms of setting up a lined, almost landfill-like containment facility with the appropriate weighbridge, etc., access arrangements, and drying areas for this spoil, which is not able to be shaped into specific stockpiles when it arrives because it's so wet, but it requires drying areas and then more permanent receiving cells to be used. So whilst 3 sites were ultimately approved through the Minister for Planning exercising fast track powers to grant the necessary planning approval, each of those fast track decisions was challenged basically for administrative review grounds on the basis that the minister had exercised their powers inappropriately. Ultimately, those decisions, those challenges failed and the minister's decision stood. And out of the 3 receiving sites, 1 site was ultimately selected to be used to receive the waste. But in the meantime, you can imagine with all of this litigation unfolding, a project paused during COVID, when of course the world is keen to see that things are progressing to the extent that they can be. There is great concern building in the community around PFAS and hence concerns that the toxic tunnel was going to be built and the spoil was going to be dumped to people's backyards was increasing. And that led to a lot of criticism in terms of the EPA's handling of the consultation process around the rushed approval of receiving sites, 3 receiving sites I've mentioned. And in turn, there was a complaint made to the Victorian Ombudsman, who then conducted a public inquiry into the EPA's conduct and ultimately did issue a report criticising the EPA's handling of the community engagement process in this process. So at the end of all of that, a receiving site has been approved and is being used, and the tunnel boring machines were ultimately turned back on after an 18-month pause. The dispute ran for the best part of 3 years in total, and the multi-billion-dollar settlement ended up taking this project to about 8.5 billion Australian dollars, so about 5.5 billion US dollars, to put that into perspective. The reason for stepping through this is to show the delay factors that can arise. Obviously, we now have a revised completion date of 2025, given we started with 2022. That's quite a delay on a major project. The perfect storm of issues, though, that has arisen in this case is certainly unique to a moment in time, which I'd like to say might not arise again, but I think there is a very real reality across many jurisdictions that it could arise again. That is a perfect storm of the environmental baseline on any project, not necessarily assessing PFAS or not necessarily assessing PFAS to the extent required to inform decisions around what contractual arrangements need to be put in place. In this instance, there was a contractual arrangement that really didn't contemplate the challenges and risks that arose here, and hence then led to a significant dispute. And in parallel with a regulator who didn't yet have a rule book set on what its expectations were in terms of managing PFAS, and in particular PFAS at such low levels of detection that had created a very high degree of concern in the community in terms of the anxiety around how this issue needed to be managed. So on that point, I'll wrap up there, but just to say that I do think that reflecting on some of these major project experiences, which can unfold even on smaller projects, is certainly helpful to hear about in terms of understanding how some of these issues playing out on the ground are influencing the changes that are made by regulators in terms of looking at how they regulate approving sites, but also how they deal with contamination levels that are accepted in the community. Thanks, Jude.
Thank you, Anna, and thank you to all the other speakers as well. So we've heard from PFAS regulatory updates and insights from experts from the US. So we had Julie, Keegan, and from the EU we had Martin, and from Australia we had Anna. So this is the last presentation. So now I will share some key talking points from PFAS regulations from my point of view as experience working as a chemical and regulatory consultant at your desk group. Next slide, please. One of the key things, of course, is the changing regulatory world, as we've already seen. We've seen with North America, Europe, and Australia with Asia Pacific. And just a fact here, so interesting. So in the US, there are now over 200 PFAS bills or policies at state level. So if anyone wants any further information, they can look at the Safer States website for further information. But that's a very interesting fact. So there is a lot of activity in the US. But in terms of other North American countries, we have Canada, who are planning to impose tighter restrictions on long chain PFAS later this year. In Mexico, there's a proposal to restrict the import and export of PFOS and PFOA. That I believe was in 2022. There's no any further updates from there. Brazil, late last year or early last year, there's a proposed bill to regulate PFAS, which concerns the sort of control, monitoring, remediation of PFAS. And we're switching over to the EU, to Europe. We've seen the sort of blanket ban on PFAS, the EU PFAS restriction proposal. But what is actually happening in the UK? We saw some sort of insight from Julie in her slides, but the UK is sort of planning to restrict PFAS for sure, but the scope will be much narrower compared to the EU PFAS restriction proposal. So there are sort of differences there. Now, moving on to Asia Pacific, we've already seen from Anna from Australia, and also recently we've seen in New Zealand them announcing that there will be a ban on the import or manufacture of cosmetic products containing PFAS from the end of 2026. We've also seen in Japan. Japan's been quite active with the CSCL, which is a REACH-like regulation. And there's a consultation which is actually open, closes in about 1 week or so on the 1st of March, regarding PFOA, isomers and its salts and related compounds. So as a whole, we can see it's quite encouraging to see globally there's more action happening and always on its way, depending which how you do that anyway. But many countries, as we've already seen, have also ratified this convention, so global conventions such as Stockholm and Rotterdam, which gives that extra further push or drive to restrict certain PFAS, such as PFOA or PFOS. Clearly, we can see that it's imperative to keep track of these sort of regulations and monitor them constantly to ensure compliance, as this changing constantly. And I've given a sort of a reference there from a paper that I co-authored with one of our partners from Haley and Aldridge, published last year, outlining some of the sort of key global PFAS regulations. And really, this is more of a reference point than anything, because as soon as we publish, there were already changes, right? So that just highlights again how ever changing this sort of regulatory world is. Next slide, please. So I'm going to hit you with another sort of fact. So an interesting fact. So did you know that there are over 16 million possibilities for PFAS in terms of the structures? But are all of them really relevant or of concern to us? The simple answer is actually no, right? My best guess would be a few hundred or a couple of thousands or 1 or 2 thousands, which would be relevant in commerce. What I mean by relevant in commerce and being handled or used by a particular sort of company or industry. This is actually based on some screening exercises that we've conducted or helped conduct with various clients in different industries, such as aerospace and defense and the automotive industry. With there being, this numerous number of PFAS possibilities or structures, identification is very important, especially with PFAS contained in products and materials. And a way to do that is to screen certain PFAS lists. I'm not going to go into much detail, but I've given some key lists, 2017 from the OECD, and some recent updates from the EPA with regards to the TSCA reporting and record keeping rule. And one thing to note that these do have, several substances, different number of lists. So there is a lot of confusion, and we've come across that from speak to many of our clients. And the key thing to remember here is this is a sort of initial way to screen the substances, or that you have within your products or materials. And this will only get you so far in terms of compliance. If I had to give a number, maybe 70% to 80%. And as mentioned maybe before in the other presentations, companies have to do their own due diligence for further compliance. Next slide, please. Thank you. As Julie demonstrated earlier, there are various different PFAS definitions. I've highlighted two of maybe the key ones. There's also the U.S. EPA definition, as we've gone through with the proposed rule. With the reporting and record keeping rule. You have the OECD, which is implemented by the EU PFAS restriction proposal as well. And with this numerous definitions, it may be important to understand what they mean and sort of the implications of it and which ones to really use, right? So the first key thing there is to identify the applicable PFAS definition based on based on the region or regulation we are concerned about, and to screen the chemical material inventory that you have with the PFAS definition. Because remember, the list that I gave you provided before, those are non-exhaustive lists, right? So other substances that match the PFAS definition or respect to PFAS definition will likely be subject to the regulatory obligations as well. And one thing I just wanted to highlight as well was that U.S. we've recently developed a PFAS identification tool or software where you can import a list of substances, and it'll be able to identify whether they are PFAS based on the different definitions that we have. So the key message is, rather than just screening against the list, also, check against the definition as well. Other topics of interest that commonly being asked or come about are fluoropolymers, right? There's a lot of questions around fluoropolymers, and even with the consultation with the EU proposal, EU restriction proposal, there are a lot of comments regarding fluoropolymers. So should the fluoropolymers which match the PFAS definition, should they come under the same bracket for restriction? There are some studies to show that it possibly could be a polymer of low concern and safe under standard conditions of use. But considering the whole life cycle, is that still the case, right? And fluoropolymers, as we know, is used in very key applications and very important for those applications for the functionality in particular. And the other sort of point is the essential and unavoidable uses. What uses of PFAS should come under the essential unavoidable uses, which are essential for for society, human health, etc. Next slide, please. Oops. Yeah, sorry, I've gone through that slide. I should have said next slide, but yeah, so next slide. Yeah, so that's sort of the key, some of the key things we've come across as a regulatory consultant. And I think conclude sort of the presentations with that. And I know there are some questions. Maybe we could go back to the first slides. Yeah, so we've had some questions, and I guess one of them was slides. I guess they are already available. And some other questions. And if you have any questions, please put them on the chat or the Q&A. So one of the questions that we had was, and I think this is to Keegan or maybe Julia, does the RCRA have reopening authority for closed sites like the circular?
Yeah, it's good. It's a good question. So RCRA does not have a sort of statutory 5-year review period like CERCLA does, but the process is going to be similar because RCRA compliance is typically effectuated through a state-issued hazardous waste permit. There may be state requirements that would require institutional controls, engineering controls, and then ongoing operations and maintenance. And there may also be an administrative consent order to perform RCRA corrective actions. So while there is not sort of the same type of statutory jumping off point for reopening as there is under CERCLA, there are many different ways in which a regulator can go back to a site that has completed corrective action under RCRA and insist that more investigation or remediation be conducted, which could arguably include some PFAS.
Thank you, Keegan. Maybe another question. I think this is towards the EU. So Martin, I think if you can provide some insight into this. So for PFAS uses in which it has already been decided that a restriction would not be appropriate, have those findings been made public? Martin, I think you're
sorry, sorry for that. Yes, the EU restriction proposal as published contains a list of all the exemptions and derogations, and those exemptions or derogations which, in view of the dossier submitters, require additional information, evidence, studies, whatever, as a supporting document, are indicated in brackets. So that they are under further assessment, and authorities have requested additional information on these exemptions and derogations during the public consultation, and they're now under assessment. So we will see further results from that assessment, presumably early next year, and could identify whether industry was able to submit corresponding details.
Thank you, Martin. So there's still some, I guess, some work with that respect as well. I think another question, with still sticking to the EU, is it typical that these EU chemical restrictions take over a decade to come into effect, given human and environmental health concerns regarding bioaccumulation and persistence? I guess they're talking about sort of the timeline.
Yeah.
As well, yeah.
Well, with respect to the timeline, a decade might be rather not that typical, even under REACH. But it is not very unlikely that a restriction proceeding takes several years from the initial proposal to the final adoption by the Commission, or even to the entry into force of the corresponding restriction. We've seen that in a broad variety of cases, even with a more focused approach. Here, the specific situation is that a broad variety of substances, a group of substances subject to the proposal, and a broad variety of exemptions and derogations need to be assessed, and that requires time. And due to the limited capacities of the authorities, it's a multi-year process. That's the entire story to that.
Thank you, Martin. I think another question, maybe, open to others as well. Are other countries besides the US discussing or concerned about the definition of PFAS? So it's open to anyone, I guess, apart from the US, maybe Anna or I guess Martin.
From the Australian perspective, yes, there is much discussion around how the definition should be approached. There is certainly, in terms of our PFAS NEMP, the National Environmental Plan in Australia, there is much reference to the OECD definition as a guidance piece, but when it comes to chemical regulation, it's certainly narrowed from there to specific compounds. But the discussion continues, and we are certainly domestically looking at what the approach is internationally.
Yeah, maybe with respect to the EU, there has been some debate on the OECD definition as a basis for the restriction proposal, although it's slightly modified, because the OECD itself stated that the definition shall not be taken as it is to adopt restrictions or other regulatory measures on a national or multinational level. And exactly that is what happened under the EU approach. So from that perspective, yes, even in the EU, there was some debate, and there still is some debate on that definition.
Yes, it's very interesting your point, Martin, that it shouldn't be used for for the regulatory purposes, but it clearly has been, right, or being
Right.
implemented. So that's very interesting that we've come to this sort of scenario, right, or situation, let's say. I know we're at 9:30 already. I've looked at the time. I don't know, Madison, if you've got some time for other questions, or I'll hand that back to you.
We can take a couple more questions if you all have time, and then wrap up after that.
Okay, sounds good. You guys all okay with that? Yeah. Okay. So question maybe for the US. So Julia Keegan, so are the past environmental issues that might guide a way forward for how to efficiently and effectively regulate PFAS, MBTE, too many abbreviations, for example, in the US, and I guess it's open to others as well.
That's a big question.
Yeah, those are
good question. And I think, I think my short answer is there's nothing that happened in the past that's sort of the perfect fit here, because we're talking about a class of chemicals. Even if you define it to be only sort of long or mid chain, or however you define it, it's hundreds of chemicals that are spread so diversely, across all these different industries and applications. And they're chemicals that, at least the long chain, they're not only persistent in the environment, they're persistent in people, and they've been used in applications where, they've either gotten into water and been ingested that way, or they've been in products where there's been, exposure like that. So while you could sort of try to say that asbestos might be some example, or I just don't think there's a perfect fit, really, historically. I don't know what you think, Keegan.
No, I agree with that. I mean, I think the only sort of immediate example for me that comes to mind is, at least with dioxins, there is a sort of formula to do a toxicity equivalent factor to try to generate, for the various dioxins, some common sort of number that you can use for risk assessment purposes. It seems to me that ultimately, as more science on various PFAS is developed, some type of formula like that to ease the ability to which we're going to evaluate PFAS at contaminated sites or for risk purposes would be helpful. And certainly dioxins are an example of doing that. But I ultimately think this problem, like many other problems, really just requires more science. And there is too much going on where the science is not yet there. And that is part of the challenge with this particular chemistry, is that we lack information. And in the absence of information, we're left with, extensive litigation and broad regulatory initiatives, some of which may work well, some of which may pose practical challenges. So I think that story is still to be written.
Yeah, and I guess one thing I would add on that is, I think there's activities going on sort of that aren't specific to PFAS, but might spill into PFAS, and address risk evaluation and risk assessment of PFAS, sort of groupings of PFAS. So for example, EPA has a cumulative risk assessment methodology that it's working on, and has a draft methodology that it's released, as well as sort of a draft discussion paper about applying that methodology to phthalates. And that's an example where if there's more science combined with that sort of methodology, then that might be a way of trying to sort of group these and get really down to brass tacks on sort of the risk versus precautionary action, which is what seems to be, particularly in the EU, what's going on with that proposal and how broad it is.
Yeah, I absolutely agree, Julia. That's exactly what happens. And to say it the other way around, potentially in a couple of years, we will discuss that the PFAS approach, irrespective whether in the US or in Europe or in other areas of the world, is somewhat the pattern for future regulations of other groups of substances, or even specific substances, when it comes to a rather generic, streamlined approach regarding risk assessment or regulatory activity in general. So it's not that much that we can refer to an existing example from the past that could be used to address and assess the details for a PFAS restriction or addressing PFAS as a phenomenon. It will be the PFAS approach that will set the scene for future regulatory activities.
Does anyone have any final thoughts, or before we hand it back to Madison? No. All right, I think we can hand it
We
back
could
to
keep
Madison.
talking for hours.
I know.
think.
Oh, yeah.
That's my
Literally,
final thought.
I know that there's a lot more questions as well. So, but
I'll have
maybe
to
we
have
can,
part 2.
yeah, part 2, or maybe they can send us the questions and we can answer that as well. I don't know, Madison could talk to that, but yeah, thank you.
Thank you to all of our fantastic speakers for joining us today. Thank you to Jude, Julia, Keegan, Anna, and Martin. We so appreciate all of you taking the time and energy to make this program happen. Thank you as well to our audience for your time and engagement today. If you missed any part of today's webinar, the recording will be available to ELI members on the website within a few business days. We encourage you to check out all of ELI's other upcoming programs, including our new monthly PFAS briefings, which you can find at eli.org. And with that, I will bring today's webinar to a close. Thank you again to everyone, and have a wonderful day or evening, depending on your time zone. Thank you so much.